Good afternoon, everyone. Welcome to today's webinar, IP for Digital Business. Today, I'm joined by Matt Lee. Welcome, Matt.
Hi, how you going?
So before we get underway, I'll do some quick housekeeping. I noticed that we've got a few people just still joining our session, so as they come in, they will obviously pick up these messages. So in the console that's presented to you, there will be a questions panel. If you have a question for Matt at any point in the presentation, please use that panel to ask your question, and we will do our absolute best to answer that as we go along. If we are unable to answer the question, I don't know if Matt will cover it yet, I'll hold off and we will do as much as we can at the end of the session. Today's session will run for about 50 minutes and there'll be time at the end of the session to ask additional questions or anything that hasn't been covered off. Matt, welcome. So You've been at IP Australia for 10 years?
Yeah, over 10 years now, so it's been a little bit of time. Yes.
Yeah, and you are our resident, expert and educator on all things IP awareness and education. And you've obviously delivered this digital business package, so over to you.
All right, thanks, Casey. So, hi everyone. As Casey has mentioned, my name is Matt. I'll be helping run the presentation today as well. So, I've been here at IP Australia, as we said before, for over 10 years. For the large portion of that, I was working in the patent examination area, examining computing and ICT related inventions. So that was a period of a good 7 years. And in the last few years, I've been working in the communication area with the startup and small business engagement team to talk to small businesses and small entities about ways that they can not only protect their intellectual property better, but also ways that they can get value out of their intellectual property as well. So today's session is going to be covering specifically intellectual property for digital business. So that means that if you're a tech startup, there's going to be lots in here for you. But even if you're a small business or some other type of business which wants to have some kind of online presence, and let's face it, most of the businesses out there today are looking to have that, whether you're selling online or contacting your customers online. Hopefully there'll be something in the session for you as well. So let's jump into it. So IP Australia is, for those of you who aren't aware, is the Australian government agency that helps to administer the registered intellectual property system. So that's patents, trademarks, designs, and plant breeders' rights. We'll be covering those in a moment. Now, we also do some other regular Australian government functions, such as negotiating international treaties and the like on intellectual property. And we also do education and awareness activities, such as the thing that we're doing today here with you. So what is intellectual property? We're going to give a quick overview of some of the basics of intellectual property. If you want a more in-depth introduction to intellectual property and some of the concepts surrounding that, I do encourage you to sign up to a webinar that we're running in 2 weeks' time on IP 101, but we'll cover some of the basic fundamentals here just in case you need a refresher. So intellectual property is defined as the application of the mind to something new and original. Or the way I like to think about it myself is that it's literally the expression of an idea in some kind of form. And that can be many different types of forms, such as a new invention, a brand, a design, an artistic creation, but this by no means is an exhaustive list. Intellectual property is literally all around you in ways that you might not consider. In terms of the digital space, if you think about data itself is going to be valuable intellectual property, because if you ever lose control of that data, it lands in the hands of a competitor, for example, then it's going to hurt your business because that data has intrinsic value. Same thing with customer contact lists and the like as well. So intellectual property can be in many different types of forms that you may not even realize too. To cover some of the types of intellectual property that you might encounter more commonly, we've got an example here of an Australian invention called the Flow Hive. Now, I know it's not the theme of today's session is meant to be about digital business, but this one was a good one because it just represents a lot of different types of intellectual property in the one particular product. So as I said, this is an Australian invention. It was invented by a family called the Andersons who live up in the northern New South Wales coast. And they are a family of beekeepers. So when you do traditional beekeeping, it's normally a pretty involved process to try and extract honey out of the hive. You have to put on a pretty cumbersome suit to protect yourself from stings. You walk up to the hive. Sometimes you'll smoke the hive to placate the bees and make it a little bit easier to access the honey. Crack open the top of the hive, pull the actual panel out with the honeycomb in it, extract the honey, then do it all in reverse by putting the panel back, putting the lid back on top, and then walking away, taking off the suit. And after that, it's quite a bit of time which has been expended. Instead, what the Andersons came up with was a better way of extracting honey. So they came up with this particular invention, and the way that it works is that there's a tap or a kind of a handle which you can pull on the side of the flow hive. You don't need to put on your protective gear. You simply walk up to the flow hive, you turn that tap, and then it'll split the honeycomb structure that you can see in the bottom right there to make the honey flow down into the jars that you've put underneath there. And you don't need to open up the hive, you don't need to disturb the bees, and therefore you don't need to put on the same protective gear or smoke as you would normally do with traditional beekeeping. So it's a much faster process. It's better for the bees because they're not as disturbed, and it's easier and more efficient as well. So pretty good invention. They ran a very successful Kickstarter campaign for it at the time, which was the most successful Kickstarter campaign at the time for any type of product on there, and they've done quite well. Now, again, the reason why I wanted to highlight this is it's because it's got a lot of different types of intellectual property all tied up with this product. And the first one that we have here is for trademarks for the brand Flow Hive. When we talk about trademarks, we're talking about brands or ways to differentiate yourself from that of other businesses in the same marketplace. So they've got a trademark on the name Flow Hive. You can also get trademarks on things like logos too. But that's not where it ends, because in Australia, you can literally get anything which differentiates your product and services from that of other competitors as a trademark. For example, Cadbury has the color purple, which is trademarked in relation to chocolate. If you ever walk down a supermarket aisle and look at the chocolate aisle and see that a wall of purple confronting you, that's probably going to be Cadbury right there. If you jump up in the shape of a star and you're selling cars, chances are you might be doing it on behalf of Toyota, who have a trademark over that particular jumping movement in relation to selling cars. If you're doing the same thing except in relation to selling planes, it might be Jetstar instead. And in Australia, we also have one trademark for a smell. It's the smell of eucalyptus as applied to golf tees. So if there's any keen golfers out there and you think that you want to smell a golf tee for good luck or whatever other purpose, then you can also know that that's a particular registered trademark here in Australia too. Moving on, we also have patents on this particular flow hive. So they have a registered patent for the split cell technology, and that picture in the bottom right is actually taken from the patent application for the flow hive too. When we talk about patents, we're talking about inventions, and inventions, as you can see here, sometimes come in the form of a mechanical apparatus, but in Australia, you can also get patents for methods and processes and ways of doing things too. We'll be exploring this in a little bit more detail later on in relation to software and the computer-related inventions. You also have a registered design, which is for the appearance of the frames of the flow hive. When we talk about designs, we're not talking about blueprints or schematics. Instead, what we're talking about is the appearance of a physical product. So generally speaking, this isn't going to apply to most digital software or technology products that you develop, simply because we're looking at physical things such as industrially applied furniture, maybe appliances, or sometimes people in the fashion industry, and we're looking at the aesthetic appeal of that particular product to see whether it's new and distinctive. Finally, we've also got a note here for copyright. Now, copyright's a little bit unusual because unlike the others, it doesn't actually require any form of registration. So here we've got the marketing videos and other type of material that they've produced, which is associated with the Kickstarter campaign and other marketing that they've done for Flow Hive, and they have copyright associated with that. And that's probably going to be the realm where some of the computing and other digital products sit. Now, as I mentioned before, there is no registration process for copyright. So unusually, compared to the others, the copyright is automatic and free. For things like patents, trademarks and designs, and one I left off, which is plant breeders' rights, which relates to people in the agriculture industries, all of those require you to apply to IP Australia before you can actually secure that right. Copyright, though, however, also just happens as soon as you put pen to paper, or as soon as you take a photograph, or as soon as you start to create your artwork as well. For those artistic creations, literary creations, dramatic works, as soon as you express the idea in that material form, it automatically has that copyright attached to it. Now, unusually, software is actually also protected by copyright as a literary work. So in the same way that novels are protected or stories, then software code is also protected in the same way. However, it's limited as well because only the expression of the particular piece of software is protected, not the functionality. So if you write your code in a particular type of programming language, whether it be Java or C or anything like that, then your software code, whether the source code or the executable code, will be protected by copyright. But if it does a particular function, other people can come along and emulate the same function using their own written code instead, because that aspect isn't protected by copyright.
So what we've got here, I suppose, are different examples, particularly with the Flow Hive, of how a business can use the multiple IP rights to put them around their business to protect their ingenuity, their innovation, and their brand, so that they can, I suppose, stop those competitors etching in on their competitive advantage.
Yeah, that's exactly right. And there's also going to be more reasons why you want to build up a portfolio of intellectual property protection as well. And I'll get to an example which will demonstrate why in a moment. One other note that I'll have is that copyright, again, because it has no registration process, isn't administered by IP Australia. Instead, it's the responsibility of the Department of Communications and the Arts as well. Okay, so the other relevant piece of intellectual property, which also doesn't require registration, is confidential information or trade secrets, and they're normally protected in the form of a non-disclosure agreement. Now, a non-disclosure agreement is simply that. It's an agreement between you and another party to keep a secret. And the most famous example that we have that most people are aware of is the Coca-Cola recipe. Now, Coca-Cola has been in business for a long time, over 100 years, and I'd say that they've done pretty well for themselves in the meantime. And they've managed to keep the Coca-Cola recipe secret for that entire time, which is no mean feat. And the way that they've done that is that if you happen to be exposed to the Coca-Cola recipe, you have to sign a pretty lengthy document which basically promises that you're going to keep that secret and not disclose it to anybody else. Now, Coca-Cola has managed to do that fairly successfully, but of course, if you have a secret and you've agreed to keep it secret, I would say that the way that I describe it is that NDAs can be fragile, because if that secret is exposed by somebody like a third party or somebody that you've given that information over to, it's really hard to put back into the box. So you can pursue them for damages for breach of that particular agreement and through the court system, but unfortunately, it's really hard once the secret is out there or the information is out there to try and get that back as well. So some people, if you happen to have a system like Coca-Cola to try and keep that under wraps, then it can be very successful. But otherwise, sometimes you want to pick and choose with the places that you might want to use it. It's also worth mentioning that in some startup communities in particular, such as when you talk to investors, be it angel investors or other venture capitalist firms, that they generally don't sign non-disclosure agreements for various reasons. One reason that I've been told is that it's pretty administratively heavy because they get lots of people approaching them with different ideas, and it's hard to keep track of all of the ideas that they're given. So they don't want to just be burdened by having NDAs and different types of agreements with so many different parties, which they have to keep track of and manage as well. So just something to be aware of.
I suppose the real question here, Matt, is that you've got trade secrets, you've got copyright, patents, trademarks, and designs. And I suppose as a business, one of the hardest things to get across in the early stages is how do you apply your strategy around that? I suppose what Matt's presenting here is that here are all the different mechanisms that you can use and you can implement. You need to obviously seek some advice on a lot of things. So, weighing up the decision to use a non-disclosure agreement versus seeking a patent, that's a very big decision, and you do need to get some really good advice about the pros and cons and the application, as well as the commercial benefit or disbenefit and risks. So here, I suppose we are presenting all of those options, but we do want you to, I suppose, think about the benefits and the risks with each of them when you're looking at your own IP strategy.
Absolutely. And I think that some of the startups I have talked to as well, to jump in and say that I need to get an NDA with every single party. But again, sometimes that going to be the right thing to do. Not only it may not be the right timing or the right person in NDA with, but also that if it's just wasting your time and effort if you're not going to actually use later on, or it may not be necessary. But again, we always encourage throughout this entire webinar, as well as I'll leave this session today, to think about what advice or help that you might need to basically get something tailored to your own situation. I guess that's a good way to segue into this, is that for those people who happen to be on a lean or bootstrap budget as well, perhaps legal advice, because it can be somewhat of an expensive process depending on what you do, maybe something that you go, okay, I'm not sure if I have the money or funds to do this right now. One thing that we've recently developed here at IP Australia is that we have the IP contract generator, and it's at the link at the bottom there, which is ipaustralia.gov.au/NDA. If you want, you can jump onto that website and have a look at what we have there, because the IP contract generator will allow you to plug in a few details of your own entity, as well as the other entity that you happen to be dealing with. And once you actually get those details into the system, it'll automatically spit out a contract, which is a basic NDA document that you can use, and then you can tailor it to your own needs as well. So it can be a really good starting point for you to say, okay, I need to just get an NDA whipped up for myself because I've got some situation that I want to keep secret. Here's a good resource that you can have that generated automatically, and it's free of charge. We don't charge you anything for making that. Again, I'd like to encourage you that if you use this a tool, that you use as a starting point, and again, tailor it to your specific situation. But again, it's something that we've done recently, and it's available to you for free.
Okay.
Now, I mentioned before that it's important to build up an IP portfolio. This is an example of a recent story that of a company called Zoox. Now, they're in the business of autonomous vehicles, so self-driving cars. And unlike some of the other companies which are in this particular space, such as Uber and Waymo, they are looking at building a vehicle from scratch. Up until very recently, they were operating in stealth mode, so nobody was quite sure what they were doing behind the scenes. And it was only at one point last year that they went public with some of the details of their operations. Also during this point as well, they happened to do a raise in the middle of last year for 500 million, and that was US dollars. So it was the equivalent of about 800 million Australian at a particular valuation of 3.2 billion US as well, which is a lot of money. It's a lot of money.
Significant, isn't it?
That's right. And this is coming from a company which hasn't sold a single thing. They haven't got a product to market. They're still in the development phase. But despite that, they've still got a valuation of $3.2 billion.
So, Matt, I'm going to ask you, where's that value at?
So the value of that particular company lies in this intellectual property. So one of the founders of this is Tim Kentley-Clay, who's an Australian as well. So he went over there with this big idea, got an American partner, Jesse Levinson, and they started working on this concept of building their own autonomous vehicle as well. As part of that process, they've developed a lot of intellectual property. And also one of the very early venture capitalist funds was also an Australian venture capitalist fund as well, which put money in there. And one of the quotes that they have is that they were willing to stump up this cash, and I think that they put up, that raise was $40 million. They were willing to stump up that cash because they recognized the value of the intellectual property that had been built up in Zoox. And not only was it something of value, but they said that, and this is a quote, is like they say, "We also note that even if the ultimate vision of the driverless taxi is not achieved, the team will still be building significant value in its IP, which should be strategic to a very fast-growing space with lots of big players watching intently. This provides some risk mitigation to getting our capital back." What they're doing is that they're saying that you have this intellectual property built up. Even if things go pear-shaped, there is a lot we can do with this intellectual property, and therefore we're more willing to take that step with you and put capital into your particular business because you've also got that portfolio built up as well. So what I wanted to kind of emphasize in here is that, again, with all those types of intellectual property we covered, whether it be trademarks, patents, even copyright and non-disclosure agreements and confidential information. If you happen to spend the time to just think about your intellectual property in your business, they can be valuable not only from a protection point of view to fend off competitors, but also to attract the investors, as we can see in this particular example as well. All right, now let's jump into a few more details. We'll be covering a few different topics along the way, on starting from some of the things that you can think about when you get your idea for your particular business venture, developing it, taking it to market, and then maybe even going overseas as well. So we'll start with this first one here, which is about computer implemented inventions and patents. Now, a lot of people that I've talked to in the startup industry, they say, I've got this great idea. I want to make sure I lock it down. And they think that the best way to lock it down is to get a patent. And it's true in a lot of cases. If you want to protect the functionality of a product, we saw before that copyright doesn't cover that. So the only way to do that instead would be to use a patent, unless you can find some other way to use a trade secret or NDA type of protection instead. However, the rules in Australia are pretty complicated in this space as well. So let's have a quick exploration. Now, why would you consider getting a patent in the first place? We have a company here which is called Longtail UX, which is a Sydney-based company, and they're in the software as a service or SaaS space. Effectively, what they do is they analyze businesses and their websites, the way that they run, and they help improve the search engine optimization or SEO of that website using some of their patented algorithms and techniques to improve the findability of the particular website as well on the internet. So by helping your business get found, obviously that's going to improve your marketing and overall visibility. So that's the type of service that they provide. And they've got this particular quote here, which just demonstrates the value of having a patent on their own technology, because it allows them to go out themselves and find those clients as well as investors, because they have taken those steps to protect their patents, protect their technology through patents. What does a patent actually give you? Well, it actually provides you with protection or a monopoly right to exploit the invention after you secure that registered patent. So that could be controlling how your product is sold, manufactured, developed, etc., etc. And it can be protected. It can protect products and services through protecting things like an actual machine. So it can be apparatuses and inventions, but also methods and processes as well.
So Matt, we have a question from one of our audience. When you say proprietary technology, what is it that you actually mean? Can you use some different words to kind of contextualize that a little bit?
Yep, so proprietary technology, again, I think is used in many different contexts, but I think that the way it was used there was that it's saying that this was technology which they had developed in-house. I'm not sure if they did it in partnership with other people or contractors coming into their organization, but it's something that they developed within the company structure and might have sought protection from it again through the patenting process. So they were able to demonstrate that they were the owners of this particular technology, and that's something that we do check as part of the patenting process, and we're able to apply for the patent and then get it secured as well and demonstrate that it passed all of the steps. Conveniently, the steps are listed below. So before I get to that, I'll just cover the second point, which is to say that registration lasts for 20 years for a standard patent, 8 years for an innovation patent, which is a slightly easier a patent to obtain, and again might be relevant for people in the software and digital space too, because you only need a short period of protection. You assess patents on many different criteria, but the main criteria that we have here are novelty, inventive step, and manual manufacture. To explain these, novelty basically looks at, is your product or is your idea something that has been done before, ever? If it hasn't been done before, we then go to the next one, inventive step. If your invention is new, what's the closest thing that was previously invented before you? And what's the difference between that and what you've got in front of you right now? And is that step significant enough, or is it a very, very small minor improvement that people would find obvious? And if you can clear that and say that, no, it's like my invention is new, it was novel, and the step is big enough to not have been obvious to people working in that particular industry, we get to the last point, which is manual manufacture. Now, this is the big sticking point when it comes to software and digital products. And again, I've had extensive experience working in the patent area, in the computing technology section, dealing with this question a lot. When the manual manufacture rule was implemented to basically say, what are the types of inventions that we want to have protected by patents? And again, patents last for up to 20 years, so it's a long time, right? There are certain types of things that under law, we say that, no, you can't have a monopoly right over that. Now, there are some clear exceptions, such as you can't patent human beings, you can't patent laws and discoveries of nature, and you can't patent purely mental processes. They all make sense. There's a common sense argument to say, no, somebody shouldn't own that. You don't want a company owning humans or the way that you should be thinking instead. So there are clear reasons for those exceptions. However, there is also an exception for purely financial and business schemes as well. So that's something, again, where we say, okay, we don't want to have those types of inventions protected because, again, they're very similar to those mental processes that we mentioned before as well. And that's not the type of thing that we want to grant inventions for. So the way that we think about digital products and services is that we say that, okay, what is it that we want to give patents for? And at IP Australia, we can distill it down to a basic question. Is your invention or does it involve some level of technical innovation, or instead, can we characterize it as a business innovation? If it's a technical innovation, then you're more likely to be able to obtain a patent. And if it's a business innovation only, you're more unlikely to get a patent. To explain the difference between these, Uber is a very successful company in the ride-sharing space. They have a number of patents. However, the main thing that Uber is known for is a ride-sharing service. That in and of itself is a business innovation because people have their own cars, and it's a scheme that allows people to use their own cars to pick up other passengers using an app and take them to a destination that they choose to do so. Uber does not have any patents which rely to that particular scheme. Instead, Uber has a number of patents on GPS technology, as well as the way that it functions with their app and processes that particular data as well. So GPS technology, in this particular instance, can be regarded as a technical innovation because they were able to take that technology, make improvements on the technical side of things to say, yes, we've got something new with GPS and a better way of using it. And the actual business innovation side, they haven't got a patent on instead. Now, you could argue that Uber might be successful for a number of reasons, but this is also a good example to say that you don't necessarily have to get a patent to be successful. And again, this will apply to a lot of people in the digital space, especially if you happen to be making an app or some other kind of web platform or digital platform instead, because if you happen to be servicing a segment of customers in an unusual way, then sure, you might be like Uber, disrupting a market and coming up with a great idea that people would love. But if it happens to be a business scheme, then you won't be able to get a patent for it, or it's unlikely that you will be able to get a patent for it because it falls more on the business innovation side than the technical innovation side as well. So really, we're looking for improvements to technology. Are you making data? Are you structuring it in a different way? Are you making a computer run faster? Are you making a system which allows you to retrieve data storage from hard drives or databases in a more efficient way? Types of things like that are more clearly going to be technical innovations. Other schemes and methods are going to be characterized as business innovations and therefore not eligible for patent protection. To give you a slightly different perspective on this same point, I've got an example here regarding blockchain. Now, blockchain is a pretty popular technology for the last few years, used for a variety of different purposes. If you happen to conceive of a new type of blockchain which has its own new data structure and satisfies the other steps that we said before of novelty and inventive step, for example, then you may be able to get a patent for that. However, if you use a particular type of existing blockchain and you use it for a new use that hadn't been contemplated for before, say using it for the fashion industry, tracking the origin of a particular dress and the like, then that's a new use of that technology. But again, it's a business type of use, which may be characterized as a business innovation, and therefore you may not be able to get a patent on it. Now, I have to emphasize that this is a fairly complex area of law. There's a lot of court cases which have been arising in the Australian court system over the last decade on this particular topic, and there's still some cases in progress at the moment as well. Suffice to say that because it's such a complex area, we really strongly encourage you to seek legal advice if you are keen on getting a patent in this space, or even if you think that you have something which might be able to be protected, or you just want to make sure for peace of mind instead. So it's something that it is, again, very complex. There are a lot of gray areas and exceptions to it as well. There are more details on our website if you want to delve into the technical side of things and the legalese. But again, we encourage you to seek legal advice on this particular topic where possible. Okay, so just got again just a follow-up question about proprietary technology means that you've applied for a patent. So not necessarily. You don't necessarily have to apply for a patent to have proprietary technology. It's more of a question of ownership. So is it something that's being created by you or perhaps your company instead? And one way that you can establish exclusive ownership is via patent, but it's not by any means exhaustive. Again, if you have it protected by some other means, such as copyright or a non-disclosure agreement, then it's proprietary technology. But you don't even need to have a formal level of protection for it to be proprietary technology. As long as it's something that you own and you can say that you own it, then it's going to be considered to be proprietary technology as well. Which actually is a good segue into the next topic, which is going to be all about ownership and the types of issues that you can face in a digital business as well. So we talked a little bit about patents and some of the ways that you can protect an idea using a patent, and some of the difficulties of that too. But that's only part of the story, because let's say that you've got your idea, you've said that, okay, I've tested it in the market, I know that I want to develop it and make something of it as well. The chances are you're going to bring other people on board. So that can be in different forms, such as bringing more employees into the business, or maybe getting some contractors to help you build your website, work on your software code, and the like as well. Or perhaps you might even want to bring in some other people as partners instead, or perhaps investors who might form part of your board. So you're going to run into other people in various capacities. So you need to have some level of protection in place, or have some consideration as to what are the implications going to be as you bring in the other people into your organization as well. The reason why you need to have such careful consideration about it is, depending on the way that these people come into your company, there's going to be different implications for intellectual property. Now, by default, under Australian law, if you have an employee during the course of their employment who creates a piece of intellectual property, whether it be a document which they're writing up in a word processor, or something more involved than that, the intellectual property of that piece of work is going to be owned by the company or by the employer. However, a contractor who's an independent contractor, if they have, in the absence of any other agreement otherwise, if they create a piece of intellectual property, such as a website, or take a photo for you, or something of that nature, the intellectual property is by default owned by the contractor. It's not owned by the company that they were doing it for. And this is a really important distinction to make, because if you have a situation where you get somebody in and they start working on your software code to help develop your product, and you haven't got an agreement because maybe they're a family friend, or maybe there's somebody that you were referred to, and it's just a quick job and they're just working quite quickly, and you didn't want to get the hassle of any paperwork. By the time that you go to launch, the last thing that you want to happen is for them to say, hey, you remember that piece of work that I did for you, a few months ago? We didn't have. I'm not too comfortable with you launching your product anymore, because I actually want to do the same thing myself. I have the intellectual property rights retained by myself. So if it's all right with you, please don't launch it, because I own the IP and I'm going to launch a different product instead.
What a pickle.
Yeah, that's not a good situation to be in. And again, by default, if there isn't a written agreement, then they will be the owners of the intellectual property.
So I suppose even the paperwork is fairly cumbersome sometimes. A quick and dirty kind of arrangement is probably not the way to do business.
No, absolutely not.
Keep it clean and document everything.
Absolutely. And again, at the early stages, it can be very, very tempting to have people come into your organization, do a quick job for you, and then not have any kind of paper trail as part of that process. But it is something that you want to, again, mitigate the risk of something happening later down the track by having that paper trail in place. Now, it then comes to the question of, what do you need to have in that agreement or that piece of paper with those other people? Now, keep in mind that this also applies to partners and other people who come into your organization, depending on any capacity as well. So you can have it as part of that employment agreement, that contract you have with the independent contractor, or even the partnership agreement as well. So the types of things that you might want to consider is, first of all, if they're bringing in existing material, or you're bringing in existing material to a product, acknowledge it. just lay it all out on the table. What is it that you're coming with? What is it that they're coming with? And just so that we can all be clear on exactly what's happening and who's pooling their resources into this organization. What are the uses of that pre-existing material that you would like to authorize? So can they go off and, if they have another side hustle, can they go and use that material for that side hustle? Can you use it, etc., as well? So make sure you're clear on exactly the usage restrictions or requirements of that pre-existing material. What's going to happen to new material that you develop? If you work together on making code, and again, this happens a lot in the software industry, where bits of code are combined together to a single product, it's all going to be mixed together. So have an idea of who's going to own that newly developed material. And generally speaking, that's going to be within the organization that the person's coming into as well, but you might have some exceptions to that. What can either party do with the new material, and does it include future updates and work? And think a little bit ahead, such as if a party leaves the organization, but that product is still in the marketplace and is still being supported, is there going to be any ownership implications about supporting that particular product going forward? Can the parties use the know-how from the relationship on other outside projects? So again, think a little bit ahead for the exit strategy, even for yourself. If you decide to go off and do another venture in a similar type of marketplace, can you then say that, okay, the information I've been exposed to, I can still utilize that for my own purposes, and possibly even work for a competitor. So this is getting into a little bit of the space of non-compete clauses and the like as well. Finally, who is responsible if a third-party rights are infringed? And as following that, what are the limitations on liability? So you want to make sure that, again, especially for that pre-existing material, as well as the newly developed material, who's going to be responsible if a mistake happens and you happen to have an impact on some existing piece of intellectual property of a competitor or someone else who's got an issue with what you've developed too. If you have all of these things as part of the written agreement, again, it's going to sort out some of the issues that you might face later on and be much less hassle, because at this particular point, when you're first getting somebody and onboarding them onto your organization, by having all of these things sorted out, it just means that when an issue arises, you can just refer back to that piece of paper to what you agreed to and stick to that without having to wrangle, argue, and otherwise negotiate an outcome, which is going to take up much more of your time and resources.
Obviously, there's a lot of detail in that, and obviously collaboration agreements and IP projects and the like do require legal advice, and so we would definitely recommend that you would work with either an IP attorney or an IP lawyer to help you navigate and draft appropriate agreements around particularly the ownership out of, I suppose, what happens once something is created, and also to how something is used following maybe a dissolution of that partnership.
Yep.
All right, let's kick along.
I also mentioned that a copy of these slides are available in the handout section of the interface as well. So you will be able to get a copy of those points. You don't need to be furiously jotting down notes to see what's on screen there as well. So you will be getting a copy of that, as well as the URL, which was at the beginning, and we'll also show at the end, which has all of this information, which is ipaustralia.gov.au/digital, which has the same information on our website too. Okay, so moving on now. So you've got your product, you've thought about the idea, you've developed your idea and built it with some other people as well, and then you've gone to market, and it's been a great success. Hooray! You're out there, customers are coming into your business, you're generating revenue, but with that comes the risk that other people have identified your particular product and said, hey, that's a great idea. I'm going to jump on that bandwagon and possibly take that idea and make my own copycat product or service, or take some of the elements that you've created and run off with it themselves. So online infringement is a real possibility nowadays, especially considering the amount of e-commerce and other types of digital services that we provide too. And not only that, it becomes quite tricky because a lot of this online infringement, if it does occur, can occur in other jurisdictions outside of Australia, making enforcement a little bit of a tricky thing to do. What we wanted to cover in this section is that what other steps that you can take if you happen to have somebody infringing your IP online. And it's not always going to be the case where you press the button and go nuclear straight away and start suing people left, right, and center, because there are a number of steps that you can take before you get to that particular stage that you should consider taking, and in some cases that you have to take before you press that nuclear button instead. So let's go through some of the things that you should consider. So the first thing to do is to get the facts. You need to figure out exactly what has happened. What is the IP that has been allegedly stolen? Do you even own that IP? Is it something that you have some level of protection on, say, for example, a trademark or a registered patent, or maybe you haven't got a registered patent or trademark instead? They also find out some of the facts about the person who's allegedly infringing you, and maybe how they might have the infringement might have occurred. Is it something that it looks like they've deliberately copied, or could it have been a mistake? And who is the person who might be behind the alleged infringement too? I've got a picture here of a logo, which is called Siege Sloth Games, which is a Canberra-based games company, and they are a video game producer. And they had an issue recently where they had their logo, which is displayed here for you instead on the screen, taken almost exactly and placed on the YouTube channel. And they said that's unusual because they haven't really encountered many parties who'd said that they wanted to get their logo and use it for other purposes, and they decided to do a little bit of investigating before they started contacting the lawyers. And it was a good thing that they did, because the YouTube channel, which had the logo placed as the official logo on that particular channel, was run by a kid who just wanted to start up his own streaming set of videos on YouTube, and just really liked the logo. He just liked the look of it. It wasn't anything to do with Siege Sloth Games or as a gaming stream. It was just that he liked the logo, was looking around for sloths, and then came across this one and said, yep, this is a good logo to use.
It's free on Google Images. Surely we can use it, right?
A lot of people will do that. They'll do a Google image search and they think that it's all freely available to use. So instead, they sent tried to get in contact with this kid to try and get the logo, and said, hey, it's good that you like our logo, but we don't really want you to use it in this particular manner as well. And they were able to get a resolution to that particular situation. I think that they may have actually had to contact YouTube in the end as well. But again, it just doesn't hurt to look at the facts of the situation, because there's also other aspects involved outside of just general IP protection. If it happens to be a kid or maybe a family or some innocuous use as well, you also have to think about the marketing and PR perspective of absolutely laying down a ton of bricks on a person who might have been innocuously using your particular image because they've just done a Google image search for a sloth or something of that nature as well. So it's important to get the facts straight before you take any further steps. Next, ask yourself, is it worth enforcing? Enforcement is generally going to be a long and involved process, especially if you go through the courts. Similarly, though, you also have to ask yourself, what is the IP that's being infringed in the first place? Sometimes you might have something which is copied, which is something which isn't particularly valuable to you in the first place. And so therefore, is it really worth your time and effort to actually go and take these steps to hunt down people who might have infringed on your product? So if it's something which is you can let slide, as unfortunate as it may be, sometimes that might be the best thing to do for your business. And other times you may decide that yes, it's valuable, or you want to pursue it for the principle of the matter instead and take action as well. But again, it's something that you need to consider at this early stage too. Next, contact the other party. There is a rule in Australia that you cannot launch online infringement proceedings without first getting in touch with the other party. And the way that you normally do that is via what's known as a cease and desist letter. So the way that you would do that in online infringement cases, though, is that you'd have to try and find the contact details in some way, shape, or form, and that can be a bit of a tricky process. So if you can't readily find the contact details of the other party, especially if they happen to be overseas, some of the things that you can do is that you can actually go to the web provider of that particular website and then see if you can, assuming that they have their own website established, which is where the infringing product is currently being hosted or sold, is that you can contact the web domain name provider to find out who registered the domain name and then find the contact details there If you have the other option that you can use as well is to try and contact the ISP or host of their particular website, which you can sometimes just simply put in a request to get their contact details for, and then the ISP will comply with that and then forward that on to you. Obviously, you'll need to demonstrate the fact that you are an intellectual property holder and the possible infringement has occurred to back up your request. In some instances, you can also get a subpoena to force the ISP or host to tell you who exactly is behind that particular website as well. Otherwise, there are some other things that you can do, which is to take action through third parties. So I've got some screenshots here of Amazon Brand Registry, the Apple iTunes Store, and also of Google, and a page that you can launch some inquiries there about intellectual property. Now, in the case where you can't readily get in contact with the infringing party, especially again if they're overseas and you haven't been successful with finding their contact details through other means, you can take action if they happen to have their product hosted on a third-party website such as Amazon, Google, or iTunes. So what you can do is that they have facilities where you can say that I'm the registered trademark holder or the intellectual property holder of a particular piece of IP. It's being infringed by this product, which is being hosted on your service, and could you please take it down? Amazon Brand Registry actually is a bit of a proactive service where you can preemptively register your trademark, and they will then use their system to monitor for instances of trademark infringement and the like too, to better help you have your goods, to prevent infringement of your goods and services on Amazon itself as well. But those are the options, and again, there's other instances of other platforms such as YouTube and Twitch, etc., where if you have copyright material, then you can also get that taken down through that particular process. So think about some of the third parties you can contact. The other option that you can use outside of the hosting platforms here is that, or you can also in some instances contact the merchant services such as PayPal and the like, and say that, again, this particular website is using PayPal, it's infringing my intellectual property, can you please stop receiving payments or facilitating payments to this particular domain or website? And so in some cases they'll also comply with that as well. So if you can't necessarily get the website taken down, it's almost the same thing and it's almost as effective, because they won't be able to receive payments anymore through those third-party merchant services too. So that's another option that you can take.
So we have a question, Matt. What do you do if someone infringes your copyright? And I suppose we're talking very generally about intellectual property, of which copyright is a right.
Yep.
But you would obviously apply each of these steps as much as you possibly can for patents, trademarks, designs in some instances. Patents probably a bit hard, and copyright.
That's right. I think actually probably the more common types of infringements, online infringements that we'd see would be in the trademark and copyright spaces. So exactly the same for copyright. Do all of these steps and for potential copyright infringement. So again, find out what the situation is. And with that Siege Sloth Games example before, that was partly a copyright type of case, as partly a trademark case because it's the logo as well. But it's very, very much a similar situation. So if somebody's got, say, a piece of artwork and they've reproduced it on their website, get the facts. Think about whether you want to pursue it, contact them, because sometimes it may be an innocuous case of copying and they'll take it down immediately. And again, that's the best outcome for you, because the infringing material is no longer online. And then if they don't necessarily acquiesce to your request, then you can start to take those other steps, such as contacting the third parties to get it taken down, or actually launching some kind of formal infringement action instead through legal mechanisms too. So it's exactly the same for copyright as opposed to the other types of intellectual property. Thanks for that question.
Just the other thing I just want to touch on briefly before we move on, Matt, is copyright and trademark content coming into the country. You and I had the opportunity to meet with the Australian Border Force team a few months back, and they also have a register that if you are noticing that you have a trademark in Australia and you're doing obviously very well, you can actually register that trademark with the Australian Border Force. So if you are noticing infringing products being being brought into the country, there are steps in which Border Force can take to seize those goods and to stop that infringing content or assets coming into the country. So there's a bit of information on our website about that also.
Yeah, so again, this will be a little bit, I guess, more applicable to those people, I guess, in this session who might be working on a particular piece of artwork or copyrighted or digital piece of bit of IP, which is applied to a product, say, a T-shirt and the like, and people happen to be selling that back into Australia as well. As Casey mentioned, again, you can contact Border Force to say that you are the registered intellectual property holder or the intellectual property holder. If you notice any of these infringing articles coming through, they'll be able to seize those at the border as well.
We've also just had one other quick question, which we're unable to answer with any definitive response at this point. So what are the costs involved to register with the Australian Border Force? If you search on the Border Force website, intellectual property, they will have, I think there is a registration fee. From memory, it may only be approximately $100, but do check with them. The Border Force website will have that information available for you.
Excellent.
Right, let's progress forward.
All right. So, okay. So the last thing that you've got is that, again, you've launched your product. You've dealt with the copycat people who have tried to steal your success, and now you want to actually go ahead and actually sell into those other overseas markets instead as well. So, you want to go and take your technology overseas, there's some things to consider before you actually go and break into those markets. Now, all of the things that we've been talking about before are generally applicable under Australian law, and unfortunately, there's no such thing as a global IP law legal system. However, we do have plenty of similarities with a lot of countries overseas due to some of the treaties that we've negotiated. So things like copyright, for example, are going to be recognized in much a similar manner in most jurisdictions all over the world, where you just simply create the copyrighted work and it's applied automatically without a registration process. However, there are some subtle differences depending on where you decide to go and the way that they treat technology, in particular digital technology as well. So we just want to highlight a few of these differences just so that you can be aware. And again, this is by no means a comprehensive list, so we encourage you that if you decide to go to a particular market to export your technology or take it into there to actually find customers, or perhaps maybe look for other expertise in your development and want to expand your operations, you find the legal advice to give you the exact situation on the ground as well. So the three major markets we want to have a look at briefly is China, the United States, and European Union, which is going to be having a focus on Germany as well. So China is obviously a big market for Australian exporters to go into and break into Asia, as well as being a big market by itself as well. They have particular restrictions on technology and the way that it's handled. One example is that with copyright, and this also applies similar to the United States as well, as we mentioned before, there's no requirement for you to register copyright. However, there is a registration process for copyright in both of these jurisdictions, and the reason they have that is that if you want to actually enforce copyright, and in the Chinese example, if you actually want to license your technology or license that copyright out, it's often a good idea to go get that copyright registered because it makes it enforceable and just opens up the possibility of much higher damages if you want to take action later on for copyright infringement. It also provides just an evidentiary base because you register the copyright, it's given a date at the point of registration, and if infringement happens after that particular date, it's very easy to prove that, say, look, I've got an official date of when my copyright existed, this infringement occurred later on. It's much easier to demonstrate that you are the owner of that particular copyright and therefore get it through the courts in a much more efficient manner too. Also with China, they have some funny restrictions. I shouldn't say that, but they have some unusual restrictions with technology importation when it comes to digital services as well. These are fairly new laws, and again, this is something that people are trying to work with at the moment, and it revolves around the way that you deal with technology import contracts. So if you happen to take some intellectual property, say in a software product, into China, and you have a partner over there which you want to license to as well, is that if the licensee, which is the person on the ground in China, makes improvements to that technology then they will own the improvements to that technology themselves under these provisions as the way it stands at the moment. There aren't any cases to actually say that this is going to be the case, which is why I said that it's an unusual situation and people are still trying to work out the effect of it. But on paper, that seems to be what it suggests too. And that's a pretty tricky situation to go around because, again, if you want to have technology and have it developed, the last thing you want to do is to lose control over that. But that seems to be what this law is suggesting that will happen to those particular improvements as well. And if you have a contract which tries to prevent this from happening, in some cases that contract may not be enforceable. It may actually be void because that law will actually surpass the contract agreement that you have as well. So again, it's something that you might want to seek advice with if you happen to go down that route. Turning to the United States, we have a concept for digital platforms called safe harbor provisions. Now, when we talk about safe harbor, we're talking about platforms such as YouTube or Twitch or the like, which allow people to upload third-party content to a particular platform, host the content, and then it's given out to other people as well. So when you're watching a video again on YouTube, you're generally watching something that somebody has uploaded, even though you're gone to the YouTube website to have a look at it. Now, if somebody uploads intellectual property infringing content, say for example it breaches copyright, if I upload the leaked episodes of Game of Thrones to YouTube, for example, then technically speaking, YouTube is the one that's providing that copyright content to you as the host provider. Now, is YouTube the one at fault here? Well, arguably, it's really the person who uploaded that video in the first place. But again, in terms of the eyes of the law, it's the person who's actually providing the content. However, there are exceptions to this to protect platform providers, and those are called safe harbor provisions. In Australia, if you happen to be a cultural institution, an educational institution, or something of a similar ilk, then you are exempt from being liable for those third-party infringements which are uploaded, as well as if you take the necessary steps to take it down. Similarly, YouTube, if we mentioned before, has the ability to take down infringing content as well. The big difference with the United States is that in Australia, we do not provide an exception to people using the platform for commercial purposes. In the United States, they do, which is why YouTube and quite a few of those other services are hosted in the United States with their servers as well, because they have that exception and they can't be prosecuted for having that third-party content uploaded to their system as well. So again, it's an interesting difference to note. Finally, if you go over to the European side and Germany in particular, they have a slightly different way of treating copyright. Copyright is intrinsically linked to the author in Germany under their particular copyright law too. So the situation is that if you go to Germany and use a developer to help you with your software development there, as we mentioned earlier in the piece, if you are under employment contract, the employment contract means that the IP would normally resolve and go straight to the company, and the company would own the IP. It's not the case when you use German developers, because the German developer will always be tied as the owner of the IP, and that can be never taken away under German copyright law. Instead, what happens is that the employer gets an exclusive license to use the software, but it's again something that you need to consider, especially if you want to then transfer that technology to another company as part of an acquisition process or some other type of thing that you might want to do too. And one of the ownership considerations there as part of that particular development arrangement. So it just shows you that the way that you actually take your technology overseas and the types of actions you have can be different depending on the country you go to and the particular laws that they have in each of those countries. Okay, so that basically brings us to the end of the session today as well. I know that there's just a few minutes left before we have to wrap up. So I just want to highlight that all of the information that I've presented today is part of a resource on our website called IP for Digital Business, basically the same as the session. So it's all hosted at ipaustralia.gov.au/digital. So there are a number of different topics here, all split up into the different stages of your business, whether you be starting out with an idea, developing it, growing it, and taking it to the market. And there's also plenty of other topics which we haven't covered, such as how domain names are treated in relation to trademarks, things about cybersecurity and physical security as well to protect your IP and the like as well. So I encourage you to have a look at that domain and our website for that more information on how to protect your digital intellectual property products and services too.
Before we close out the session, Matt, we do have a few questions which I'll ask you, but for anyone who obviously didn't want to hang around, maybe your lunch break is up and you've listened to us for an hour, we will be sending those resources that Matt sent, Matt mentioned earlier, and we'll also have a short survey that will be emailed to you. We'd be so grateful if you could please give us your honest feedback. If you like what we did, tell us. If you feel that there's some spaces that we can improve, we'd love to know. A large portion of what we do here at IP Australia is try and develop educational resources to help Australian business understand, apply and manage their IP. And so if we can in any way help you do that better, we'd love to know about it so we can build that into our future work program. Okay, just before we close out the session, I've got a question here. Can IP infringement be applied to basic things like HTML code or even layouts on your website or an app?
Yes, it can. So copyright is an area which will apply to these particular types of things. So as I mentioned before, all code, and that includes HTML code, is protected by copyright. However, if we're talking specifically about HTML code, again, it's going to be the way that the code is actually written out, which should be protected. And then if it's quite easy to get around simply because there's many different ways to have the same look and feel of a web page, written in slightly different HTML code, or perhaps as slightly different, written in a slightly different way as well. So the code is protected by copyright. Now, in terms of the actual layout, again, if it has a particular visual, if it can be characterized in artistic work, then that can also be protected by copyright. But what is interesting in this instance is that in some jurisdictions, for example, the US is obviously the most popular market for a lot of digital companies and services as well, is that you can get a thing over there called utility patents, which are slightly similar to the way that we have innovation patents here, but they protect user interfaces, and that includes the particular appearance of websites. So I think Google, from memory, has a patent on their search interface, which is that blank white screen, the Google logo, and a single search bar in the middle of it with no other types of interfering text. Apple has some protections on its interface, especially on its iPhone products and the like as well. And so, yes, you can have those interfaces actually protected by those utility patents in the US as well. So it's something to also keep in mind, even if you don't want to get protection for your own interfaces, is to see whether there's something out there already which has that protection there in the first place.
All right, so Matt, another question has come through. If someone decides to protect a software under a patent, or if they have a software that is applicable to patent, are the updates or new versions of that particular software protected as an extension under the pre-existing patent? Or would you have to update the patent or apply for a new patent? I'm fairly confident you can't update patents, so forgive me that I've said that.
Well, there are certain ways you can update patents up until a certain stage. So I guess the answer to this question is it depends. Generally speaking, the way that patents operate is that you have a section of the patent application called the claims. And the claims sets out the legal monopoly that you have for that particular patent, and that's generally an expression in words of saying, I have a product or an invention which is a method of doing X, and that method involves this particular step followed by this particular step, such as retrieving data from a database, passing the database through a language filter. The language filter then sending the data to a hard drive, doing a comparison step with something, etc., etc., etc. The way that your claims are written will determine exactly what level of protection that you have and what it covers. If you make an improvement to your particular product and it's covered under the scope of that original protection, then there's nothing else that you need to do because it's already there. However, in many instances, you'll come up with a new feature or a new improvement later down the track, and it's not covered by that particular patent, in which case then there are a few other options that you can do. Sometimes, yes, it's worthwhile filing a new patent, and there might be strategic reasons for doing that as well. Otherwise, you can also file what's called a patent of addition, which allows you to have those features incorporated and basically extend the protection that you have with your original patent through what's called that patent of addition. There are some details on the website a little bit about that. It is a bit of a technical field, so I won't go into too much detail, but yes, you do have those options. Probably a good idea to seek legal advice though, because
Definitely.
a lot of people will actually file a new patent because there are specific reasons for doing so, such as if you want to go and use it as a basis for taking your product into particular overseas markets and the like as well. So there's a lot of variables at play.
I think the number one thing there is that when you are working with a patent attorney to draft that patent specification is that you give your attorney as much information about what you're doing now, what you're doing in the next couple of months and even the next couple of years, so that they can actually help prepare that patent filing strategy for you and with you so that you can get the best, I suppose, bang for buck in your patent application. All right, gang, so that's where we're going to close out today. I want to thank everyone who obviously attended today's seminar. If anyone would like to obviously get in touch with us, we've got our contact details online. We also have a fairly active Facebook page. And if you've got any further questions, you may certainly connect through our call centre. The number there is 1300 65 1010, and the team will direct any inquiries that we receive and that we can answer through to our team. Thank you very much again. We will obviously email slides and a survey, and we hope you all have a very enjoyable rest of your day. Thanks, Matt, again for hosting this seminar.
No worries. Thanks for joining us.
Goodbye, everyone.